Our featured speaker this evening will be the minister whose portfolio includes the responsibility for the administration of justice in Barbados. I now invite General and Minister of Home Affairs, the Honourable Adriel Brathwaite, to deliver the feature address. Minister Brathwaite.
Thank you. President of the Inter-American Court of Human Rights, Mr. Diego Garcia-Sayan, distinguished judges of the Inter-American Court of Human Rights, Justice Winston Anderson of the Caribbean Court of Justice, Your Honorable Mr. Justice Marston Gibson, Chief Justice of Barbados, other judges of the High Court and Court of Appeal of Barbados, Assistant Secretary General, Organization of American States, His Excellency Mr. Albert Ramdin, members of Cabinet, members of Parliament, distinguished guests, ladies and gentlemen, good evening. Before I get into my formal presentation, I just thought I would update you as to why Diego Garcia-Sayan is so familiar with the history of Barbados. He advised us earlier today that in Peru, where he is from, that indeed that there were three opportunities to learn the English language, and one of them was to come to the law school here in Barbados. And although that was in the 1920s and 30s, I'm not sure if he indeed had the opportunity to attend the law school here in Barbados, but I found that piece of information very, very interesting. Thus his familiarity with the history of this great nation. This sitting of the court takes place for the first time in the Caribbean region, and Barbados is immeasurably pleased to have the special sitting convened in our jurisdiction. We consider it an unparalleled honor that we have been considered to host the Inter-American Court of Human Rights. The protection of human rights is one of the pillars of our Constitution and has been at the forefront of the endeavors of successive governments since Barbados became an independent nation. The framers of the Barbados Constitution enshrine fundamental human rights in the highest law of this country. In so doing, they did not create new rights for Barbadians. They merely gave formal protection to the rights which each citizen should currently possess. These entitlements, which we know as human rights, cannot be separated from our humanity. They are not benefits born of an individual's nationality or status. They're rights that exist because the individual exists. They're fundamental because their violation results in the degradation of the individual's innate dignity as a human being. Barbadians enjoy an array of fundamental human rights: the right to a name and a nationality, to the protection of private life, the right to a safe home, the right to freedom of speech, to liberty and personal security, the right to humane treatment, the right to judicial protection, to work and fair pay, to move freely within this country of ours. These rights are often exercised with little regard for the intricate legislative and judicial architecture which preserves and enforces them. In Barbados, this architecture is multi-tiered and is founded squarely on the supreme law of the land. Chapter 3 of our Constitution outlines the fundamental rights and freedoms which are guaranteed to individuals and prescribes the limited circumstances in which those rights may be circumscribed. As you're no doubt aware, Barbados, as a member of the OAS, accepted the OAS Charter, which established the Inter-American Commission on Human Rights, which is the principal institution for human rights protection and promotion in the Americas. The Inter-American Commission monitors the human rights guarantees in the American Convention with respect to those OAS member states that have accepted the Convention. Barbados accepted the Convention in 1981. The American Convention created the Inter-American Court of Human Rights. Barbados accepted the jurisdiction of the Inter-American Court on the 2nd of June 2000, and in so doing, gave the court the right to make legally binding decisions on breaches of the civil and political rights enshrined in the Convention. Barbados has appeared as a respondent before the court on in Boyce et al. Versus Barbados and in Tyrone de Costa Cadogan versus Barbados. And both of these encounters, the courts found that Barbados was in breach of certain protections enshrined in the American Convention on Human Rights. Barbados was held to have violated, among other areas, Article 2, which stipulates that member states undertake the necessary legislative and other measures necessary to give effect to the rights and freedoms enshrined in the Convention. Article 4.1, which speaks to the right to be arbitrarily deprived of one's life. Article 4.2, which requires a competent court to determine the applicability of the death penalty. Article 8, which guarantees the right to a fair trial. And Article 25, regarding the right to judicial protection. Pursuant to the court's rulings in those cases, the government of Barbados has undertaken to address its convention violations resulting from the retention of the mandatory death penalty. Presently, we are taking the necessary steps to ensure the laws of Barbados, particularly Section of the Offences Against the Person Act and Section 26 of the Constitution of Barbados, complies with the American Convention. In addition, several other pieces of legislation will be amended during the course of the next couple of months, in particular the Corporal Punishment Act, the Juvenile Offenders Act, the Reformatory and Industrial Schools Act, the Prevention of Cruelty to Children Act, to bring these pieces of legislation in compliance with the human rights provision of the Convention. In his maiden speech, by the principles common to both the UN Charter and the American Convention. We're continually strengthening our democratic institutions. We respect the rule of law, and we are forging ahead in building a just society in which each citizen can participate to his or her fullest capacity. As my colleague, the Minister of Foreign Affairs and Foreign Trade, Senator Maxine McLean, said at the opening session of the Commonwealth Human Rights Seminar held in Barbados in June this year, we are not perfect, but we strive for perfection. There's still much to be done. But I can assure you that the protection of human rights remains at the core of our developmental strategy. And we recognize and accept that notwithstanding the enormity of the challenge, it is one which Barbados will not ignore. However, permit me to return to the cases of Boyce and Joseph and Cadogan, which raise some difficult issues which, as a jurisdiction, in my opinion, have to be addressed. Inter-American Court in these decisions seem to have accepted that the final determination of human rights issues under our Constitution reposes in itself. This goes against the teaching of all the Caribbean-trained constitutional law attorneys like myself. In the interest of stimulating debate on this issue and of exculpating myself should it become necessary, I refer you to a recent article by the Honorable Justice Winston Anderson, and I shall point him out in the audience to you just in case it's necessary, entitled "The IAS and its Impact on Caribbean Human Rights Law, Constitutional Law Implications and the Role of the CCJ." Justice Anderson argues that the Inter-American Court is of the opinion that the Convention supersedes Barbados' Constitution and the jurisdiction of the Caribbean Court of Justice, which is our country's highest court of appeal. In his words, the Court does not consider Caribbean constitutions or the interpretation of those constitutions by a domestic court, be it the Privy Council or the CCJ, to be the final human rights guaranteed under the constitutions. Rather, according to the Inter-American Court, the American Convention is supreme, and it's the Inter-American Court's decisions which present the definitive source of legitimacy for interpretations of meanings of human rights. I ask you, is it indeed possible that Barbados could have agreed that a convention will be supreme to its constitution? Was this what was intended when we accepted the jurisdiction of the court, or was this an indirect consequence? Justice Anderson's article further suggests that Barbados and CARICOM should give urgent and continued consideration to the development of Caribbean human rights, with the Caribbean Court of Justice being the guardian of such human rights. As a University of the West Indies trained attorney at law and a Caribbean citizen, I must confess my bias towards a system that allows the Caribbean Court of Justice to have responsibility for the determination and development of our human rights jurisprudence. That is not to say that I do not recognize and accept the role that the Inter-American Court has played in enhancing the development of human rights in the Caribbean, even in countries that have not accepted the jurisdiction of the court. I do in fact recognize the contribution of the court. Indeed, in the aforementioned article, Justice Anderson opines that, and I quote, that in addition to inspiring the activity of several human rights organizations in the Caribbean, the Inter-American human rights system has had a positive effect on institutions of governance of our Caribbean societies. The executive, legislative, and judicial branches have all been influenced, I believe for the better, by the Inter-American system of human rights, end quote. The challenge, therefore, for Barbados is to determine how we should develop our CARICOM human rights, assign responsibility of guardian same to the Caribbean jurists and the Caribbean Court of Justice, while simultaneously continue to accept the jurisdiction of the Inter-American Court. I'm not offering a solution this afternoon, but I'm raising this issue in the hope that you, the distinguished judges of the Inter-American Court of Human Rights, judges, and my colleagues at the bar will ponder on these issues during this week while the court is sitting here in Barbados. We are honored by your presence and look forward to a highly productive session of the Inter-American Court of Human Rights, as together we combine to tackle the problems which Barbadians generally care about and to achieve the objective of peace, order, and good governance which our Constitution hopes to achieve. On a personal note, having met Justice Margaret Macaulay, I think this is the second time that we have met, and have engaged with respect to her love and her wish to see the American Court being incorporated more in the English-speaking Caribbean. I thought I would raise the particular challenges that I see personally that have come as a result of the judgments that came from your court, ma'am. And I do look forward to finding a way that our own jurisprudence and the jurisprudence coming out of the Inter-American Court can work in harmony towards the enhancements of human rights in Barbados and beyond. I thank you.